The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Today we have Aaron Carmack, our CEO, and Amanda Poe, our Director of Human Resources, for the Cardinal Services 2019 Employer Update webinar. Good afternoon, Amanda and Aaron.
Good afternoon.
Good afternoon. Well, let's go ahead and dive right into the employer update. With the Equal Pay Act, as of 2017, you were not allowed to be asking applicants about past pay history. And that includes on the application or in an interview. And oddly enough, there are some civil penalties for this in 2024 if you're asking about pay history. So not sure why the long gap in there, because in 2019, as of January 1st, the Bureau of Labor and Industries, they're the ones enforcing civil issues outside of the courts or through the courts and civil liability, the Equal Pay Act, everything else becomes effective in there. And we'll go over the other pieces here in the next few slides here. So 2019, it's supposed to become effective. That said, there's quite a bit of talk because BOLI didn't release the Oregon Administrative Rules which govern the Equal Pay Act until November of 2018. That gave employers just a real short period of time before it became effective. So there may be some changes in these dates, but these are the current ones at this point. Now, I should note real quick that California and Washington each have their own versions of the Equal Pay Act. Amanda?
All right, so when you think of the Equal Pay Act, you might think of this as discrimination between the sexes. Well, it's been a long time illegal to discriminate in this manner. Like, for a long time, you've not been able to discriminate. But did you know that as of today, women earn only 82 cents for every dollar earned by men? It's kind of crazy to think about. The Oregon Equal Pay Act brings in other protected classes beyond just the sexes. So we're talking race, color, religion, sexual orientation, national origin, marital status, age, uniform service, and disability. So here's the definition of comparable character. It's pretty broad. Keep in mind that the job title or the long-winded job description that you have on file may not necessarily reflect the true duties or the work that the employee is performing. So you need to be sure to lump all the jobs together that really do fit together. So here on this next slide, you'll see that there are many reasons that you may want to pay employees at different rates of pay. Oh, my slide didn't change. Oh, there they are. So here are the ones prescribed in the law. Now, these can be pretty subjective, but it will be interesting to see how the courts deal with this. You can pay employees different rates of pay based on education, location, seniority, traveling, experience, just a wide variety of things. So here on this next slide, you'll see that ideally you have some type of form or fancy spreadsheet so you can document the reason or reasons for differences in compensation. Keep in mind, compensation includes more than just salary. You also need to include benefits and bonuses. So if all employees are compensated equally, say everybody makes minimum wage, then your analysis is going to end here. So in summary, you'll see on this next slide, first thing to remember is that you do not want to ask about pay history when you're screening applications, when you're interviewing your potential candidates, and when you're hiring and onboarding your employees. That's the easy part. Now, the law wants you to ensure that employees who perform work of comparable character are compensated equally. So if there are pay deviations, then you will need to address them. If you want an affirmative defense against a lawsuit, then you can do what's called an equal pay analysis. But there's no requirement in the law that you do this. Aaron?
So as Amanda mentioned, there's no requirement that you do an equal pay analysis. If you do that, it does protect you against punitive damages should it go to a civil case. They're in front of BOLI. If there's a complaint filed in front of BOLI's not going to hold it against you nor use it as evidence in some type of wage claim there. So do you do this yourself? If you're the employer, if you're a small mom and pop with 3 or 4 employees, your ability to complete something like this is going to really vary from a Fortune 500 company. And now, of course, there's going to be all sorts of variations in between there. So the law is ambiguous because it realizes that there are going to be some different levels of complexity or how complete you do an equal pay analysis. So if you're unsure if you can do that and maybe you want to use an outside party like an HR consulting service, presumably they're going to do a much better job on this. But either way, both the employer and an outside party, those can be subpoenaed if it went to a civil suit. So you may want to use an attorney and with your contact with the attorney regarding the analysis, that's going to be protected under attorney-client privilege. So moving on to protected groups, should you be doing an equal pay analysis for them? Well, if you're going to do a complete analysis, you're going to need to analyze all the different protected groups. Now, obviously, you're not going to necessarily know all the different protected groups. And I was reading BOLI's notes on here. It says, oh, yes, you can go ahead and do this on protected groups. You can survey your employees, just need to treat it sensitively. And my gut went, oh, no, that's not a good thing, because I don't think I should have a list of which employee is of what religion anywhere at the business on here. But that may become the norm. We are going to have to see how this kind of plays out in BOLI guidance or in the law. So as I mentioned, the law was meant to be ambiguous. Let me jump over to the next slide here. It was meant to be ambiguous. So I talked about the Fortune 500 company and the small mom and pop out there. They're going to have different resources. The Fortune 500 company is going to have specialists who presumably focus just on these type of things on here. Problem is, with that type of ambiguity in terms of how much you have to do, there's no real guidance from BOLI, nor is there any case law at this point here. And just coming from a risk manager's background, I always want to, what's the bare minimum so we can work up from there on that? There's no real guidance. So you're going to have to take a look at your situation. If you're a restaurant and all but your managers make minimum wage, you're pretty much not much exposure, kind of like the example that Amanda gave. But if you have a wide variety of jobs and it's difficult to see if they're not of comparable character, they may have different job titles, but if they're not or may be of comparable character, well, you should be doing quite a bit more on that. So moving on to Oregon Saves, I mentioned this in last year's webinar, that throughout 2018 through 2020, Oregon is implementing Oregon Saves, meaning that you either have to use the Oregon Saves product as a retirement plan or use your own retirement plan. The most common people are most familiar with is a 401k. Now, the good news is if you're with these number of employees, the state's going to notify you when you need to have that in place, when you need to register and that. And I would just mention that if you're going to be required to have something and you don't currently have a plan, highly recommend taking a look at a 401k in terms of the different funds and the fees and just all the different options that a 401k can offer employees for retention purposes. Amanda?
Oh, joy. Look at that. Another form. Oregon has its own new W-4 form this year. So Oregon says we need this as the federal form does not correctly withhold for Oregon employees. Well, guess what? They only made this form 7 pages long, as if the 2-page federal form isn't confusing enough for employees. But no worries, if you're partnered with Cardinal for your employee screening and onboarding, we're going to take care of you. Now here on the next slide, you'll see that minimum wage is going to go up again in July. This time it goes up 50 cents in each region. It'll still be a few more years though until we get to that top rate. Aaron?
So there's a new licensing requirement, and the term for this is the property service contractors. I had to go and look that up at the state. The state uses that for janitorial companies. I have no idea exactly why, but as of 2018, you must be licensed as a contractor in order to perform janitorial services. Amanda?
All right, so as you can see, Bully posted a new poster this year. And at this point, it's just an optional poster regarding workplace bullying. Now, Cardinal will be adding this to our Oregon labor law posters that we publish in the summer. And I also heard that OSHA is going to be more active with cases regarding bullying. So speaking of poor behavior, here on the next slide, you'll see that harassment continues to be a widespread problem across the nation. So we professionals in HR had hoped that most of the really egregious behavior had mostly gone away. The #MeToo movement dispelled that myth. So it's imperative that you have a no-tolerance harassment policy in place. And if you do have a complaint, take it seriously and investigate it right away. Cardinal will be happy to assist you in reviewing and updating your policies and your employee handbook. Just give us a call. We can also help guide you regarding investigation best practices when you do have complaints. So here on this next slide, you'll see that the IRS made a notable change in their standard mileage rate for business purposes. Many employers do use this rate for reimbursement, and it's up 3.5 cents from 2018. And back to you, Aaron.
Great, thank you. So the Fair Labor Standards Act, that is the law at the federal level determining whether or not somebody needs to be paid overtime or is exempt from overtime. Now, I'd understood that in March of 2019 that they were looking at maybe changing the hours spent on work versus administrative. So think of a restaurant manager, they're helping customers for a certain amount of time, and then they're doing paperwork, for lack of a better term, for a certain amount of time. And there was a test on how much of each they would have to be required to do in a day in order to qualify for this. The second thing on there that they may be looking at and coming out with guidance or new rules on is the salary in order to qualify. Well, March 19, I think, is pretty optimistic. With the government shutdown, this isn't a high priority. So I suspect it'll be, if it rolls out in 2019, it'll be later on in 2019. So in terms of possible legislative items, there's one party with a supermajority in Oregon, and I understand that high on the list is the paid family leave. So we're looking at maybe a new tax on both the employee and employer. Remains to be seen. That's kind of just what we've heard. In terms of the annual budget shortfall, we had if you remember Measure 97, we had a gross receipts tax proposed and got voted down by voters. My understanding is that some legislators haven't quite given up on that idea, so they may rebrand this and call it a business activity tax. And I've also heard that if it does pass, that they would probably refer it to voters. So we'll have to see on that one. Back to you, Allison.
Thanks so much for your presentations today, Aaron and Amanda. If employers have any questions, they can email us at support@cardinal-services.com or give us a call at 800-342-4742. Everyone have a wonderful afternoon.